Start. Para. The issue in the present writ petition is whether the petitioner can take advantage of the Vivad Se Vishwas relief for MSMEs scheme floated by the Finance Ministry of the Government (Union of India) by an office memorandum dated 11th April 2023. Under this scheme, the government proposed to refund 90% of the liquidated damages deducted under contracts entered into with the government on the fulfillment of the eligibility conditions more particularly set out in the said office memorandum. It is in this context that the petitioner, although seeking various reliefs in the above petition, has restricted itself to prayer clause 3 and 3b, which read thus: Para. The petitioner is a company engaged in rendering services of electronic automation, information, communication and technical solutions, and manufacturing of meteorological instruments, radar equipment, GPS devices, search devices, navigators, etc. to various government bodies and PSU undertakings carrying out shipbuilding in exercise of power conferred by subsection (1) read with subsection (9) of section 7 and subsection (2) read with subsection (3) of section 8 of the Micro, Small and Medium Enterprise Development Act 2006. The Ministry of Micro, Small and Medium Enterprise on 26th June 2020 issued notification number 2119. Under this notification, the government framed criteria inter alia for classifying an enterprise as a micro, small and a medium enterprise under the MSME Act, and also the form and procedure for filing the memorandum known as Udyam registration, which was to take effect from 1st July 2020. Clause 8 of the said notification provided for updation of information and the transition period of classification. Clause 8 (5) and which is relevant for our purpose stated that in case of an upward change in terms of investment in plant and machinery or equipment or turnover or both, and consequent reclassification, an enterprise would maintain its prevailing status till the expiry of 1 year from the close of the year of registration. Thereafter, by another notification dated 18th October 2022, Clause 8 (5) was substituted. The substituted Clause 8 (5) provided that in case of an upward change in terms of investment in plant and machinery or equipment or turnover or both, and consequent reclassification, an enterprise shall continue to avail of all non-tax benefits of the category it was in before the reclassification for a period of 3 years from the date of such upward change. On 10th May 2021, the petitioner was registered as a medium enterprise under the MSME Act and obtained an Udyam registration certificate. Para. Between 19th February 2020 and 31st March 2022, the petitioner was unable to deliver various projects contracted with the government public sector undertakings due to constraints arising from the COVID-19 lockdown. Due to these defaults, the contracting government undertaking authority deducted liquidated damages under the contracts entered into with the petitioner. Since the government received many references from micro, small and medium enterprises (MSMEs) regarding difficulties faced by them due to the COVID-19 pandemic. By an office memorandum dated 6th February 2023, the Finance Ministry framed the VSV scheme, under which it proposed to refund 95% of the liquidated damages deducted under contract with government inter alia on the conditions that the contractor should be registered as a medium, small or micro enterprise with the Ministry of MSME as on 31st March 2022, and the original delivery period was between 19th February 2020 and 31st March 2022. The government e-marketplace was also directed to provide an online portal for the purpose of implementing the VSV scheme. Stop.